All right, the Imo State People's Democratic Party ousted Governor Honourable Emeka Ihedioha has returned to the Supreme Court. The ousted governor is seeking a redress to the verdict that removed him from office.
As it stands, it seems the controversy surrounding the Apex Court ruling will not go away anytime soon.
Mr. Ihedioha's counsel has filed an application at the Supreme Court urging the Apex Court to set aside the January 14th judgment. And joining us now to discuss this is Patrice Akwara, legal practitioner. He joins us from our Abuja studios. Thank you so much, Mr. Akwara, for joining us this morning.
Thank you. Good morning.
Good morning.
Thank you for having me.
So now it is formal. Mr. Ihedioha's counsel, like you heard, has filed an application to the Supreme Court. But do tell us, what are the principles here, and how does it apply to this particular case?
Well, thank you very much. The thing is, under the Supreme Court rules, Order 8, Rule 16, when the Supreme Court gives judgment, anybody the Supreme Court can review that judgment on some stipulated headings, such as maybe to correct a clerical error, if the judgment was given per incurium, that is to say, without really adverting their minds to the law, or if the judgment was obtained by fraud. So, having regard to these stipulated headings under the Order 8, Rule 16, perhaps Emeka Ihedioha instructed his counsel to file a review of the judgment delivered on the 14th of January. So, they haven't filed their briefs, haven't filed their appeal for review. They will now articulate these points to show that they are coming under one or two or all of the headings permissible under the Supreme Court rules. So that's exactly the background picture of what has happened now.
Right, Patrice, I want to come in here. The counsel had 8 points, 8 headings.
Yes.
Talked about judgment per incurium, talked about the possibility of having, the winning vote, the cumulative vote that won the election more than the votes cast. Talked about even the jurisdiction of the court, talked about the fact that the tribunal and the Court of Appeal has said no way on this judgment. How did the Supreme Court? And went for the decided case between I think and a motor company in the 80s as regards the Supreme Court turning and upturning a decision saying that it's not valable. I think they were quoting Charles Chikunfo Puta on that judgment and the likes. So he's made an 8-point strong statement here. What's your reaction to that?
Well, my reaction to that will be, for now, we only have one half of a coin, one part of a coin, Every coin has 2 sides to it. So we only have one side of a coin. Obviously, they must have served Hope Uzodinma or his counsel. So by the time they now make their reply, we will now know the other side of the coin. But from what they have filed, number one, let me state clearly, and what we are taught at the law school, the Supreme Court has no jurisdiction to sit on appeal over its own judgment. That's clear. At the end of, because there must be an end to litigation. Supreme Court has no inherent or constitutional jurisdiction to sit under its own appeal or under its own judgment. So the Nigerian Constitution, 1999 Constitution, did not confer the Supreme Court with any such powers or jurisdiction as it were. But then, just like I said earlier, under the Supreme Court rules, Supreme Court can entertain in order not to perpetuate illegality also, I forgot to say also that where a judgment was given, but the effect of that judgment is lost in ambiguity, a party can go back so that the purport of that judgment can be stated clearly. That is to say, the judgment can have effect by a clear understanding of that judgment. So what when I read the 8 points the learned counsel to Emeka Ihedioha, the learned silk Agabi filed, I found out that most of them, in my own humble opinion, because I'm giving this opinion as a lawyer, I wear several caps in Imo State where I come from, but this opinion I'm giving as a lawyer, my own opinion is that most of them appear to invite the Supreme Court to sit on appeal of its own judgment. So it's curious what the Supreme Court will come up with, because one of the points they raised there was that the result as declared by the Supreme Court, that the Supreme Court has no jurisdiction to declare result, and that the figures, when you tally the figures, you find out that the accredited voters for that election is less than the votes allotted to each of the candidates when you tally them together. Most of all these things should have been canvassed at the lower court, because the Hope Uzodinma and his counsel, from the tribunal, brought out everything that they wanted to use to prosecute their petition. So it was an ample opportunity, both at the level of the tribunal and at the level of the Court of Appeal, for them to bring out these discrepancies. But they left it. In fact, they treated, what I heard was that they treated it with levity, because they didn't even want to go into all those things, except at the Court of Appeal, where a dissenting judgment was given to really look at what Uzodinma brought. So canvassing it afresh, or for the very first time at the Supreme Court, it's like the judgment of the Supreme Court when it had to do with disqualifying Uche Nwosu for double candidacy. When Emeka Ihedioha's counsel submitted that Supreme Court had by disqualifying Uche Nwosu for double candidacy, that Hope Uzodinma was no longer validly the candidate for APC. The Supreme Court told them that you cannot canvass fresh issues, because this issue was not canvassed at the tribunal or at the Court of Appeal. The Supreme Court, in their judgment, said that you cannot canvass fresh issues at the level of the Supreme Court, because under the law, under the practice, under the rules of court, it's called ambushment. You have to canvass it and also serve the opponent so that they can have a look at it. So you cannot bring fresh issues at the level of the Supreme Court. The Supreme Court it sits an appeal. It's not fact finding. It's the trial court that makes all this finding of fact, so that by the time they will exhaust it, and that is why if you are appealing, you will appeal with the records of what has happened at the various levels of court, so that the Supreme Court will take a very holistic look of all the finding of facts, at those level of court. So bringing all these issues in the first instance at the Court of Appeal, well, I want to know what the learned justices will decide on that matter, on that issue. Thank you.
We are all waiting to see what the Supreme Court justices decide on that matter. But to further buttress the point that you've made regarding the total number of votes cast in these elections, it has been proven from over time that it exceeded the number of accredited voters. Now, can this be seen as a case of per incurrium, which basically states that it was a thorough lack of care on the part of these justices in a case where they failed to pay attention to the relevant statutory legal provision or precedents?
Okay. Well, I've had it canvassed that while it appeared as if the number of accredited voters was less than the number of total votes cast, was simply because the results, all the data, including results, accredited voters, cancelled votes, votes allotted to each candidate, all the data from the 388 polling units, which Hope Uzodinma alleged were excluded from collation. If you add them, it will now increase the number of accredited voters, which lays heavy weight on what Hope Uzodinma alleged, because if having regard to the fact that INEC excluded the collation of that result, they didn't tabulate it in the final collation. So the Supreme Court now asked them, or I think at the level of the tribunal, the INEC said it was a forged result. But if you say that something is forged, you have to bring the original version of what you allege is forged. That is just law, because if you assert that it's forged, under a strike law that he who asserts must prove. The proof of assertion is not in making the statement, it's in proving. And I also learned that at the level of it was at the level of Court of Appeal that they brought the incident form. It's like manufacturing a document when the matter had already started. So that's the way the Supreme Court would have looked at it. All these things are elementary basis of law. We learned all these things at law school, not even in practice. So if you now go, if at the level of the tribunal, which sat for upwards of more than 30 days, you were not
Mr.
able
Patrice
to say that
Akwara,
something
I'm going
was
to have
forged.
to come in here. We're going on a short break now, but when we come back, you will land on your point. Okay. This is The Morning Show here on Arise News. Please stay with us.
Welcome back to The Morning Show here on Arise News. We're still discussing the Imo governorship elections and Supreme Court matter. Patrice Akwara, a legal practitioner, is now at Abuja Studios to help us look at this critically. Thank you so much for staying with us. I don't know if you would like to land on that point you're making before the break, before I ask you my next question.
Okay. So that is briefly, that's exactly what it is. If they had, taking the data into cognizance, the data of what happened in the 388 booths they excluded, if they had taken it into cognizance, then you have to now reconfigure the total number of accredited voters to make it to now obviously exceed and make some reasonable sense. So that is what I have to say on that aspect.
All right. Let me just ask you about the chances of this at the Supreme Court reversing itself, because is it not correct to say that the Supreme Court is usually reluctant to reverse itself because it is the apex court of the land, and when it does this, it prefers to rely on a case in the future? And this happened last in the 80s, and it's usually about, minimal error, so to say. Also, you would recall that the former NBA chairman, in the person of J.B. Daudu, was seriously reprimanded by the apex court of the land about a decade ago when he also tried and applied to reverse in the case of Andy Uba. In your own experience, would you categorize what has just happened in the Imo instance as a minimal error, and so the chances are likely for Mr. Ihedioha? What's your take on that?
I will tell you from the outset, before I go directly into your question.
Okay.
I will tell you from the outset. Yeah.
Go ahead.
Okay. I'll tell you from my own, although Emeka Ihedioha, his mother is from my own area, so he's like a distant cousin. But I'll tell you, the Emeka Ihedioha did not win that election constitutionally, so it's even in the interest of Imo that elect, because Emeka Ihedioha did not satisfy the constitutional requirement of scoring a quarter of the total votes cast in 2/3 of the local government. Anybody who said he won that election has no respect or fear for God. It's just the truth of the matter. I'm speaking as a lawyer in this matter and as a child of God, which all of us claim to be. That is number one. Number two, it is in the interest of justice that the learned justices finds it, anyhow they find it, it's okay. But it's in the interest of justice that they should, there's what we call stare decisis, although it doesn't apply to them, but their decisions apply to others. At the time they start reviewing all these cases here and there, even those whose cases were decided in 1950 may even come for review. So I think that they should, maintain, because when you read, I read in details the judgment, the ratio de sedendae, that is the reason behind their judgment. If there are margins of error, it's very minimal. If there are margins of error, it's very minimal, because I look at it that if you say that somebody, in every booth, like I know very, very well, and I think we should, in order to strengthen our electoral procedure and law, we should take the evidence of the security agencies very serious. In this last election, actually, I contested for the Federal House of Assembly, that is from even Emeka Ihedioha's constituency. Every booth had security agents there. Every booth had security agents there. And if, because of the inelegant way INEC handles election, let me respectfully leave it at that, the inelegant way, the security agents, all of them receive a copy of the results, which is produced in a form that all of them are produced simultaneously. I think that form has as many as you have agents there or candidates. You have a copy given to you and security agents. So it can be, it's even more than tripartite. It's more than, it can, like we had about, maybe about more than 17 governorship candidates in Imo State. So it was in a duplicate form of up to 17, inclusive of the security agents. So, and each of them can be tendered as the same as the original. Each of them can be, because they were produced at the same time. And the court will lay weight on it. Because it's not enough for INEC to just favor a particular candidate and return that particular candidate without having regard to, just like in some constituencies, in my own constituency, during my own election, there was no single result sheet. Yet the next day, INEC produced results. This is in my own election. But I didn't go to court. I just left the whole thing because...
Patrice, I'd like to ask a very salient question. You said constitutionally we all know that Emeka Ihedioha did not win the election. Why did INEC return him? Second question, and I'll cite the case.
Thank you.
No, hang on a minute. I'll just double that up with a question. Then I'll cite the case of Adegoke Motors Limited versus Adesanya in 1986, where the legal seal, just Chukwudifo Puta said, and I quote, "Justices of this court are human beings capable of erring. It will certainly be short-sighted arrogance not to accept the obvious truth. It is also true that the court can do inestimable good through its wise decision. Similarly, the court can do incalculable harm through its mistakes. When, therefore, it appears to the learned counsel that any decision of the court has been given per incurium, such counsel shall have the boldness and courage to ask such decision shall be overruled. The court has the power to overrule itself and has done so in the past, for it gladly accepts that it is far better to admit an error than to preserve an error." This is in consonance with your point, and I'm going back to you. Justice Chukwudifo Puta, legal success, the court has the power to overrule itself. Can the Supreme Court do that? And why did INEC return a man that was not constitutionally verified and certified as a winner of an election? Shouldn't they have called for a rerun like the case in Osun and other states?
Thank you. Thank you very much. Having particular regard to what Justice Ofuta said, he said, per incurium, the court can overrule itself when it has given a decision per incurium. That is to say, without having regard to the law. So it's not just like maybe come and review. It must be, if you want them to review, it must be maybe they didn't advert their minds to the provisions of the law. And then the counsel now, boldly, as he has been encouraged, comes up and brings it up to them so that my justices, this decision was given in contravention to this particular law. So that is when they... Now, like I said earlier, and you asked, if you go to equity, you must go there with a clean heart. Like I said, anybody who says His Excellency, Right Honourable Emeka Ihedioha won that election doesn't have any respect for God. Because while we were there, all of us were there when INEC was collating the result. At the end of announcing the results, then there was this time for them to go and, tabulate everything and come and declare the result and return. We thought, everybody felt, because Emeka only won, I think, 12. He only had a quarter. When you combine the ones he won and the one he scored up to a quarter as constitutionally provided, they are only in, I think, either 12 or 13 local government. I didn't come with mine, because I wrote all these things down. He only won in either 13 or 12. That I say 13 or 12 doesn't mean I'm not certain of it, but I know it's one of them because I wrote it down in my diary.
Okay, so just move on because of time, real quickly. Because of time, just move on. He needed to, yes, he needed to have gotten that up in 18 because 18 is to third of 27. 18 is, and I also wrote a legal opinion and sent to, because to PD, because all of us are from Cons. I wrote a legal opinion and sent to them, but they didn't. And if you also check, most of the parties canvassed for this, but at the level of the tribunal, all they needed, maybe I wouldn't want to say anything about the lawyers.
Okay.
Because
Mr. Patrice Akwara,
I don't think.
We have to thank you so much. Interestingly, yes, none of the petitions was against that two-thirds spread you talked about. But we do thank you for your contributions this morning on the show. Much appreciated. And that brings us to the end of the show today. I am Adesua Omorwan.
I'm Rufai City.
And I'm Shaito Atigari. Thank you for watching. You can also follow us on all our social media handles showing now on the screen with live streaming on arise.tv.